Uh, we left off with a brief diversion into section 67,
Yes.
which I took for the purpose of dealing with the point against me made by Leonard Frampton Tennant in the context of looking at the location of different categories of members in the proviso, which is where he relied on that point. I have nothing more to say on that particular point, and I'm going to say no more in my oral submissions on the third and fourth provisos, unless you have any questions for me in relation to that. I turn next to the fifth proviso, and I can say that I'm not going to say any more than I said in my opening about the fifth proviso and what is said in paragraph 59 of our skeleton. It's a short point. It was a matter that the judge found supportive, but it couldn't be determinative on its own, and I rest my submissions on A, what I said this morning in brief summary, and B, what's in the skeleton. The point, my lady, I can see you, and perhaps I'm not being helpful by saying that. The point is, why would the point in our favour in relation to the fifth proviso, just to summarise it, is this. The Section 67 had come into force in 1997 and then had been amended to bring into force the revised terms of Section 67 that I showed you earlier, or referred you to earlier, in tab 45 of Bundle 3, protected and detrimental modifications.
Yes, and those modifications were made a little later.
The version that I took you to with protected and detrimental modifications were in force by the time of the 2000 deed, which introduced for the first time the fifth proviso. And if you just have a look at the proviso, I will make the point, because I can see it's sensible to just explain it without going into any great detail. If you look at the fifth proviso, it simply prevents any amendments which would breach Section 67 of the Pensions Act, 1995.
Yes.
All right. And an attempt to modify a protected, a subsisting right, which would be of a pensioner, would be a protected modification, and if the routes round that provided for under the Act, which in the case of pensioners is a consent requirement only, and in the case of deferreds and actives is a consent or an actuarial equivalence, if those aren't followed, then you can't make the amendment now under the rules, as well as facing the consequences of the breach under the Act. Now, by this time, the consequences of a breach under the Act are not that it's void, but it's voidable, which means the pension regulator has to decide whether to void it, and there are reporting requirements. But there are civil penalties as well, without there being any question of whether it's void or voidable. So, what this is doing is turning into an additional layer of protection for members under the rules, a form of the statutory protection that's in force. Okay, and it's saying that if you breach Section 67, in other words, if you don't comply with Section 67, you can't, under this power of amendment, make the amendment.
Okay, so it sort of beefs up the voidable nature of it by prohibiting.
Yes, it does. And there's this debate to be had about the extent to which it well, there's no debate that it adds something to the power of amendment. It adds an additional layer of protection because in the case of active members, whereas under the third proviso you could, under exception C, by a majority vote through an amendment to past service rights, even if that's an unlikely thing, you could. Whereas under section 67, you would have to comply with the consent requirements, which are different. They're individual member consent.
Okay, but
do you see where?
Yeah, well, I see that point, but I suppose it comes back to my Lord Justice Lewison's point about where does this go?
Well, exactly. Can I say where it goes, one way or the other? My learned friend says all that happened here was that belt and braces, bootstrap, the draftsman has effectively incorporated the statute that applies anyway into the power of amendment. We say that it's pretty odd, on one view, that they did that without making some amendment, consequentially, to the third proviso, because now you simply can't use the third proviso in either exception B or exception C, because you can't vote through by a majority resolution, and it may be that it's less of a point in relation to exception B, because exception B allows you to have substantially equivalent benefits, but those are not necessarily the same thing as the very technical actuarial equivalence requirements that section 67 applies. So to all intents and purposes, the third proviso, exceptions B and C, in the case of active members' past service interests, is now otiose. And it's, if the draftsman was making a positive decision to include within the power amendment, which he didn't have to, new proviso 5, why weren't some consequential amendments made to new proviso, to old proviso 3?
I think I appreciate, which I didn't really before, that it does have some effect because it changes what is merely voidable into something that is, it changes something
can't be done. Yes, it changes something that is only voidable into something that can't be done.
In other words, the draftsman is not simply lazily adding a reference to the statute, but actually by then in some form had been in place for some while.
Exactly. And furthermore, it also adds in necessarily then the strict actuarial equivalence and consent requirements, which don't mirror exception B and C. And that's an oddity of drafting. It's not on its own determinative, because it could just be, well, it doesn't matter, we don't need to make that change, but you have the point. And the last thing I'll say, as I have now developed it at your invitation, is just to say, in response to the point that my learned friend said yesterday about the Mr. Justice Nugee decision in Carr and Thales. I'll give you the reference. I don't think you need to look at it. Again, it's Authorities tab 31, which is bundle 3, at page 881, and it's paragraph 64, where Mr. Justice Nugee said it was and is, in my experience, not at all uncommon for those drafting rules to incorporate the effect of statutory provisions into their rules, even if the statutory provisions are overriding and do not need to be reproduced. That, as a general observation, is, we wouldn't dissent from that, and it would be dangerous to seek to dissent from something that Mr. Justice Nugee said based on his very wide experience. But it doesn't address the issue in the present case, which is what the correct interpretation is of a power amendment that has in fact been amended to include express reference to a particular statutory provision, leaving the remainder of that power of amendment untouched. And that dictum from Mr. Justice Newty doesn't address that particular point and leaves the debate at the point that I left it before I mentioned that particular case. That's the fifth proviso. And I apologise if, in an attempt to slightly expedite matters, I skated over that too lightly initially. Thank you for asking me the question. I'm next going to deal with the relevance of the right to terminate to the relevance of the existence of a right to terminate pensionable service. This was my point 7 in my opening this morning. And I can take this reasonably briefly, but I just want to expand a little bit on what I said in my opening. The point here is that the BBC contends that insufficient weight was given by the judge to the fact that the BBC had a unilateral right to terminate accrual under Rule 22 in the 1949 deed as a precursor to winding up the scheme, and that there was no coherent reason why the BBC would not also have been given a bilateral right to modify accrual. First, we say to that, the judge placed particular weight on the ordinary meaning of the words and other textual matters, in particular the structure of the third and fourth proviso, and he was right to do so. This should and was seen by him as peripheral in the context of that debate. Secondly, as I said this morning, there's nothing incoherent about the drafter giving the BBC less scope to modify the rate of accrual through a power of amendment than it had under Rule 22 to terminate accrual altogether. On any view, the drafter has given the BBC less scope to modify accrual because the power of amendment is vested in the trustee, subject to BBC consent. It follows that the debate we're engaged in is related to the extent of the restriction on the ability of the BBC to modify future accrual through the amendment power. There's nothing incoherent for the drafter to have provided that in order to modify the rate of accrual, the BBC would require both that the trustee decided to do so and that, unless either the A or B exceptions were satisfied, it would be necessary to obtain the majority agreement of the members. That simply means that changes to future accrual rates in any ongoing scheme, which is the situation we're contemplating, not the termination of the scheme, would be subject of negotiations, just as would be necessary if the BBC wanted to make reductions to existing pay. And we say that this level of protection makes all the more sense in the context of a benefit that at its outset was conceived as being a reward for long service. Members were being encouraged to commit themselves to the BBC service in the long term for the reward of a pension at the end, and were being provided with some protection, some because of the exceptions to the proviso, against making that commitment only for the level of that potential reward to be watered down. In the 1949 to 1955 period, my lady, my lords, the BBC could, by dismissing an employee, prevent, I don't use that in a pejorative sense, but that is factually correct, causally, prevent that member getting any pension at all. Once short service benefit, leaving service benefit came in 1955, they plainly couldn't take that away, but on the BBC's case, they could, despite the fact that it's still intended structurally as a long service scheme, they could remove the forward-looking component of that. And on our case, that's not possible. Absolutely. It is possible through the exceptions, and there's nothing incoherent about that balance. And it shouldn't be seen as structurally a necessary component of this sort of scheme that you should have both a right to terminate completely and a flexible right, or more flexible right than the one we've got here, to the BBC to procure amendments in the ongoing situation through the power of amendment. So, without getting into the reasonable and practical effect section of my submissions, which is coming up in a moment, just on the narrow point of whether the existence of the right to terminate in the 1949 deed in the terms in which it was, it should have been regarded by the judge as sufficient to drive him to a different conclusion about the meaning of the words in the third proviso. The answer is no.
But shouldn't we be looking at freezing and winding up in the current rules?
Well, I was just coming to the current rules. Sorry, my lord.
Because, I mean, one difference that strikes me about the power of amendment and the power to freeze the scheme is that, as I understand it, the power of amendment can be exercised so as to propose an amendment to, say, active new benefit members, but not other types of members. Whereas if the BBC decides to exercise its power, you say to stop accruals, but it isn't that, it's a power to stop contributions. Yes. It does so in relation to the scheme as a whole.
Yes.
So it can't pick and choose as between different categories of active member and say, well, we're going to stop contributing as regards final salary members, but we're not going to stop contributing as regards career average members. It's got to terminate the whole scheme.
Yes. Well, if you see the right to terminate the whole scheme as if you see the right to be able to terminate accrual, I say right, the ability to terminate accrual for different subgroups of active members as critical to the balance of power, if I can put it that way, commercially within the scheme, then it is correct that you can't use the freezing and winding up provision in section 18. I should say, and flag for your lordship, and it may be that my learned friend Mr. Green will say something about this more specifically, because it's more in his territory, but we know from a footnote in the BBC's skeleton that there is a dispute between the BBC and the trustee about the precise way in which the ability of the trustee to continue with the scheme, notwithstanding notice of freezing or termination from the BBC. So one's a little reluctant to get drawn into too much debate about the scope of regulation of Section 18 without understanding more details about that particular dispute. But be that as it may, the point still remains. Why does the fact that the only way that the BBC itself can terminate accrual in the case of subgroups of members, the only way in which they can do that would be through persuading the trustee to exercise a power of amendment? Why does that drive, or should that drive, the court to the conclusion that the provisos, the third proviso, can't be construed as covering future service benefits? Because the proviso does provide the BBC with a mechanism to procure, if you want to put it that way, termination or reduction of accrual through the power of amendment. There are protections put in place, we would say, that are reasonable and proper and coherent, that still allow for our construction. And even in the modern day scenario of looking at it under freezing and winding up, the same arguments apply. And those are the arguments I've just put. It's perfectly coherent when you're arguing about the level of restriction that there should be on BBC's ability to use with the trustee the power of amendment. It's about degrees of restriction. And that's been, if you like, the policy choice since 1949. And there's no reason to suggest that it should be regarded as having changed and affected the intention of the drafter ever since. I would strongly reject any suggestion that it must be the case if the only way to terminate accrual otherwise would be to close the entire scheme, that necessarily means that you can't construe interests as including future service benefits. That in essence is our position, our submission on that point. And when I come to deal with reasonable practical effect in just a moment, I'll be pointing to other ways in which the BBC has open to it under the current trust deeds and rules to control its costs, other than the power of termination and the power of amendment. And I'll come to those, if I may, at that point, because it's convenient to do so at that moment. But there are other routes to cost control. And indeed, back in 1949, there were other routes to cost control. One of them is, short of terminating the scheme, is to dismiss employees and set them up in some other arrangement if necessary. And that shouldn't be, that should not be overlooked or ignored. The other way of cost control, natural cost control in the 1949 arrangement, is that they would, even without the BBC dismissing large groups of members, necessarily have had members leaving before normal retirement age and therefore not getting a pension at all. So that kind of cost control was built into the 1949 scheme, natural cost control. I accept that that's not present in the current deed and rules, but there are other mechanisms which I'll come to in due course. That's all I was going to say on the right to terminate. I made some submissions in opening about Rule 10.6. I gave you my submissions at that point. I'm not going to add to them now, so I can move on from there. I'm next going to turn to the role of the actuary. I did cover this a little bit in opening, but I do need to say a little bit more about it now. The relevant section in our skeleton, if it's of assistance, and on which I rely, is paragraph 50. We summarise in one paragraph there our position, which is that the judge didn't, as suggested by the BBC, make an error in not placing sufficient weight on the role given to the actuary. We make the point that it makes perfect sense for simplicity for the drafter to have assigned to the actuary the task of assessing the extent of any prejudice rather than seeking to reserve a role for the actuary in respect of only those amendments where an actuarial calculation was required. And we summarise it by saying that the role given to the actuary is at best neutral in respect of the meaning of the word interest in the context of the third proviso. The BBC says, this is para 35 of their skeleton, that the fact that the actuary is involved tells you that the actuary is supposed to be carrying out a valuation when considering there is substantial prejudice, and that this would simply not be possible in respect to future service benefits. We say that misses the point that it makes perfect sense for the determination of substantial prejudice to be placed in the hands of the actuary, so that if there are any complicated valuation issues, they can be dealt with if necessary. Although, obviously, in many cases, this will be a simple and easy provision to apply, and precise and complex valuations won't be required, as per what I said earlier today. If you were looking only in isolation at an amendment to terminate future accrual, and that's it, there's no practical difficulty in that, and the actuary is perfectly well qualified, if not best qualified, to make that qualitative assessment. We referred at the trial below, in this context, to a case involving another case of Mr. Justice Nugee, Sterling, which you will find in sorry, lost my reference. Give me a moment. It's
tab 20.
Yes, thank you. Bundle 2, tab 20. And if you could look just at paragraph 33, I should, just by way of introduction to paragraph 33, tell you that in this case, Sterling, the power of amendment had a proviso that provided that no amendment could substantially prejudice benefits accrued due. Benefits accrued due. A very unusual fetter or proviso because of the addition of the word due after accrued. And the question in the case is whether, because of the word due, that needed to be read as only referring to benefits that had actually become payable, or whether it really meant nothing more than benefits accrued, and that therefore there would be a final salary link. And we refer to paragraph 33 only because here Mr. Justice Nugee is making some helpful comments about the roles of actuaries in performing tasks under the rules of the scheme. There are other difficulties with Mr. Newman's construction. One of them is this: the protection of payments that have already accrued due would only require the trustees to identify what payments had already accrued due. That might or might not require the assistance of an administrator or an actuary to identify what the benefits were. But the proviso requires the trustees to form a view as to whether the alteration substantially reduces in aggregate the value of the benefits accrued due, as to which, the quotes, the decision of the trustees acting on the advice of the actuary shall be final. This contains, it seems to me, a number of indications that what the draftsman had in mind was a package of benefits which might require some valuation. So the fact that the proviso envisaged the need for actuarial advice, my lady, my lords, in order to determine whether there was a substantial reduction in aggregate value, counted against the proviso applying only to benefits that had fallen due for payment, as that would only require the identification of what the benefits were. In the present case, there can be no such similar objection. The actuary is given a role because the determination of substantial prejudice might require actuarial valuation or calculation, but that does support the conclusion that the drafter envisaged the need for actuarial valuation or actuarial expertise. It doesn't mean that that was required in every case. I just also point out in the case of Atos, on which my learned friend referred you to two parts of the judgment of Lady Justice Aspelin in Atos, I just flag up for the court another part of that judgment which provides support for the submission that the actuary can perfectly sensibly be given a role beyond the making of calculations. This is at Authorities tab 35. And the relevant section is paragraph 63 to 70. The issue in this case was what was meant by the actuary shall determine something, and what the nature of the determination that the actuary should be undertaking was. And this is a point on which I lost, as it can be seen. But the short point that you can draw from this passage, which I'm not going to read out, but it's there, is that it makes it clear that the Court of Appeal in Atos saw no reason why matters that an actuary could determine, to use the word in the rules in Atos, should be limited to matters that are calculated. Obviously, as the other passages in this judgment, which you've already been taken to demonstrate, that is not an exercise of a discretion, certainly not in the fiduciary sense, by an actuary. It's an exercise of professional judgment. But actuaries are experienced and used to exercising professional judgment, both in pure calculation, but also in other related actuarial determinations. And making the sort of qualitative determination that's required by the proviso in this case is well within the expertise of the actuary, and it's a perfectly sensible, and we would suggest standard sort of matter to ask the actuary to give an opinion on, to enable either the amendment to proceed or not to proceed. That's certainly the last reference to Atos that I shall make. Additionally, the BBC suggests that the actuary can't value or make an assessment as to the value sufficient to give the certificate in relation to future service benefits. And I gave you my points on this morning, but just to summarise them again, making expert assumptions about the future falls squarely into the role of the actuary. There's no reason why an actuary can't make assumptions about when a member would cease working for the BBC, which is the example at paragraph 35 of the BBC skeleton, where the BBC says that's not for the actuary. Indeed, that's precisely an assumption that the actuary would have to make in 1949 to advise on funding levels for the reason that I gave in my opening. And it's precisely the sort of assumption that will be made nowadays in assessing the value of the overall active service member past service liabilities, to allow for the possibility that some will leave service in the future before NRA and therefore will be subject to revaluation at potentially a different rate from those who stay in service until normal retirement, and whose increases incrementally over that period of time before they get to retirement and take their pension only come through salary increases. Those are my submissions on the role of the actuary. And my last substantial section is reasonable and practical effect, courage, after which I will deal very briefly with final salary link and very, very briefly with Bradbury, so you can see where I'm going. I'll take a few minutes on reasonable and practical effect, but other than that, we're moving quite swiftly towards a conclusion, which I say for the benefit not only of the court but for my learned friends, so that they know where we're going. So, on reasonable and practical effect, the first main submission made by the BBC is that the judge did not apply the full terms of the dictum, noting that he did not refer to that part of the dictum that refers to not unduly fettering amendment powers. It may be sensible to look at the dictum, which you will see in Courage at Volume 1, Tab 2. It's page 505F in the judgment, which is page 41 in the bundle. Before I consider this question, I should make some general observations on the approach which I conceive ought to be adopted by the court to the construction of the trust deed and rules of a pension scheme. First, there are no special rules of construction applicable to a pension scheme. Nevertheless, its provisions should, wherever possible, be construed to give reasonable and practical effect to the scheme, bearing in mind that it has to be operated against a constantly changing commercial background. It is important to avoid unduly fettering the power to amend the provisions of the scheme, thereby preventing the parties from making those changes which may be required by the exigencies of commercial life. And I will read on, because it's important for you to get the context. This isn't a part that's cited against me. This is particularly the case where the scheme is intended to be for the benefit not of the employees of a single company, but a group of companies. The composition of the group may constantly change as companies are disposed of and new companies are acquired, and such changes may need to be reflected by modifications to the scheme. I'll come back to that context in the last two sentences in due course. But I highlight it while we're looking at the dictum now. The BBC skeleton at paragraphs 17 to 19 criticises the judge in this way. The judge did not appear to accept or apply the full terms of the dictum about not unduly fettering the construction of an amendment power so as to enable it to meet the exigencies of commercial life. And then they set out what they say is the full quotation, but immediately below, which is part of that which I read to you just now. And the judge, to be fair to him, at judgment paragraph 27, all he was doing was citing paragraph 16 of Lord Hodge from Barnardo's, who only went to the end of the part which says, wherever possible be construed to give reasonable and practical effect to the scheme. But in any event, the learned judge, we say, didn't overlook or cannot have overlooked the need to consider the commercial exigencies of life. And I'll show you what he does say about reasonable and practical effect. It's at paragraph 49 of the judgment. No, it's not. Yes, it is. Sorry.
Uh, 48.
48. 48. He refers to the Lord Hodge citation, which he previously set out at paragraph 27. He also refers to a passage in the first instance decision of Deputy High Court Judge Penelope Reid, QC, in Wedgwood. And I'll show you that paragraph 44, only because it demonstrates that, having read that and referred to that submission in paragraph 48, he clearly had in mind the relevant part of the Courage dictum, the specific part that it is suggested he may not have, may have overlooked or did not give sufficient force to. It's volume 3, tab 26. And the relevant paragraph is sorry, will you give me just a moment? 44.
Well, that refers to the exigencies of commercial law.
It does. And yeah, here we are. Thank you. It's fair to say that the deputy judge, having been through a construction exercise.
Sorry, which judge are you referring to?
The judge in Wedgwood.
Oh, the judge.
I'm sorry.
Judge,
Just to give you the context for this. By way of background, there is really very limited discussion in authority since Courage of precisely what Mr. Justice Millett really meant about the commercial exigencies aspect of what he was saying in that famous dictum. There's been plenty of discussion about reasonable and practical effect in a general sense, and about the other aspect of that that he specifically referred to, not giving too overly technical or impractical a construction. But the need not to unduly fetter the ability to amend the scheme to take account of the commercial exigencies, whatever those might be, is not something that's been discussed in terms of what exactly was meant there and in what sorts of situations it might apply in subsequent authorities. What the deputy judge in Wedgwood did was simply to add it into the balance at the end of a construction exercise, and state as fact, so to speak, having borne in mind halfway down the paragraph that it's important to avoid unduly fettering a power to amend, going on to say a power of amendment which prevented the employer from curtailing the right of existing members to continue to accrue benefits in circumstances where the employer was in financial difficulties and finding it difficult to fund the plan, makes far less sense than a construction which protects rights which members have gained through past employment but enables the employer to stop those benefits accruing in the future. That's it. There's no discussion about why that apparently general principle expressed there, that it makes sense to take that approach to construing the power of amendment in the context of attempts to stop future accrual. Why, for example, that must always be the case, if it is the case. Now, in the circumstances of the Wedgwood scheme, it may very well have been an entirely appropriate approach to take, but it will depend on, amongst other things, presumably, because there isn't any discussion of this in authority, on A, whether commercial exigencies include the cost to the employer without regard to the loss of the benefit of the future service accrual that would otherwise occur at all, and if so, how that is to be dealt with as part of the overall balancing exercise. If, for example, in the particular scheme in question, there are a number of ways, both historically and currently, in which an employer can control costs, it may very well be that you should not impute an intention to the drafter of the power of amendment, that in addition to those other methods, the power of amendment should be construed as enabling future service accrual to be curtailed in order to cut those costs. So, my learned friend didn't take you to Wedgwood in his opening submissions, and no doubt he'll say what he wants to say about it in reply, having not said that in his opening, but he did rely upon it in front of the judge. The judge took it into account, as expressed in paragraph 48, and dealt with it, we say, in an entirely appropriate way in paragraph 49. I see the force of those points, but to say that one must try to give reasonable and practical effect to the scheme rather begs the question how the scheme is intended to work. We would agree with that, and we would include within how it's intended to work what all the other cost control mechanisms might be within the scheme, potentially outside the scheme as well, but certainly within the scheme. Here it seems clear as a matter of language and as a matter of the overall structure of third proviso that as far as amendments are concerned, it's intended to work as I have suggested. So far as Wedgwood is concerned, I can see there's a possible tension between my view and the view taken by the learned judge in that case. But the terms of the amendment power there were different and referred not to interest but to rights. I think that the tension to which he's referring there is not that in isolation he would not apply commercial exigencies in the way that she did in 44. I think it's a reference to a broader tension, which is that the learned judge in Wedgwood had held that rights in a feta did not protect future service benefits. That was a rights feta, this is an interest feta, and clearly the learned judge's view in our case is that if there is such a tension, it's resolved most sensibly by taking the view that interest is capable of, and in the context in which it appears in our deed, is broader in meaning than rights was in the particular context in Wedgwood. I only say that by way of explanation of what it may be, or is likely that the judge actually meant by that. Anyway, the short point is that the judge took the dictum of Mr. Justice Millett into account. Did he give insufficient weight to what Mr. Justice Millett said? Well, the first point to make is to remind you, respectfully, of the context in which Mr. Justice Millett's comments were made, and I read you the concluding words of the paragraph. Mr. Justice Millett's focus was not on the cost of running the scheme. The commercial exigencies to which he was referring were the need to substitute new employers into the scheme upon group restructuring. So it doesn't give direct support other than through the breadth of the language that he chose to use when expressed in that particular context, to a broader approach that commercial exigencies include costs of the scheme. Well, it may very well be that that could be the case, but certainly it doesn't tell you what the answer to the consideration of commercial exigencies should be. And I made the point in my opening this morning that it should not necessarily be the case that the answer is always the same and that it should favour the employer. Because if you get into that territory and make an absolute principle of it, you are offending Bernardo's paragraph 28. I took you to that in my opening. In addition, the other point I highlighted in my opening this morning is that in our submission it's plainly wrong to suggest, as the BBC does at paragraph 19 of its skeleton, that the disparity of pay as between those with and without DB pensions can be said to be something that was either in the contemplation of Mr. Justice Millett in 1987 or indeed in the mind of the drafter in 1949. Firstly, that really is an impermissible use of hindsight on the part of the BBC, akin to the impermissible use of hindsight in the Bernardo's case, it having been found there by the Supreme Court to have been impermissible to place weight on the fact that it would be common sense now for the trustees in that case to have had a power to change the index used by the scheme if RPI ceased properly to reflect the changes in the cost of living. That's para 29 of the Supreme Court judgment. So, whilst it's of course correct that the drafter would have intended to make the scheme workable from a practical perspective in 1949, and I'll come back to that in a moment, how it works from a practical perspective, one must not and should not use hindsight to credit the drafter with a level of foresight that's totally unrealistic. Back at that time, the idea that there might be a whole group of BBC employees who were on different pay rates or had different pension benefits was completely out of the question. All employees had to be members of this pension scheme. Full stop. It was a compulsory scheme, and the payment of the contributions provided for under the rules was compulsory if you wanted to work for the BBC, and the reward you got was the long service benefit that was provided for in the original rules, with an amendment in 1955. And as I mentioned in my opening, there's a second distinct answer to the reliance the BBC places on disparity of play, because it can't be right that it could be said objectively to have been in the contemplation of the drafter that the power of amendment might have to be used in the future to help correct the disparity of pay as between those with, in the scheme, DB pensions and those outside the scheme, no DB pensions. That's a concern, disparity of pay, that's extrinsic to the scheme, which the drafter would not have had in reasonable contemplation. It concerned differences in overall BBC remuneration policy treatment as between members of the scheme and non-members of the scheme. It's not about a comparison between the benefits offered by the scheme to two different classes of member. So it's more a matter of overall employee-employer relations. It's an HR issue, as I said this morning. It's certainly nothing like the sort of practical concerns as to how a scheme could be run that Mr. Justice Millett was addressing, and it's not even focused on the cost of the scheme in its own right. It's the cost of the scheme in comparison with an extrinsic comparator. And the final point about courage is that, notwithstanding what Mr. Justice Millett said, that is a case in which the power of amendment was given an interpretation that did place a limit on the ability of the employer to control the costs of the scheme, because it was held that the fetter protected the final salary link. Not to be forgotten. So if Mr. Justice Millett thought that the commercial exigencies of life included cost control and that should always be regarded as one of the commercial exigencies to be taken into account, he either wouldn't have ended up with the result that he actually ended up with, or he at least would have said why that was balanced out by something else, neither of which happened. So, as one leaves courage, the message is very contextual and not applied to an amendment that would certainly have controlled cost in that case. We then move to the judgment of Lady Justice Arden in the BA case, Stevens and Bell, which we can see because she cited and approved in her judgment in MNRPF at Authorities tab 14, page 325, the relevant section from Stevens and Bell. So, at paragraph 30 in Stena, MNRPF, Lady Justice Arden refers to a series of paragraphs in her judgment in British Airways. And you'll see that at paragraph 28 of the citation from BA, so that's the top right-hand column, in the BA case, she said, second, a pension scheme should be construed so to give a reasonable and practical effect to the scheme. The administration of a pension fund is a complex matter, and it seems to me that it would be crying for the moon to expect the draftsman to have legislated exhaustively for every eventuality. As Mr. Justice Millett said, and then she sets out the dictum, including the sentence, it's important to avoid unduly fettering the power to amend the provisions of the scheme, thereby preventing the parties from making those changes which may be required by the exigencies of commercial life. Then she goes on to say, in other words, it's necessary to test competing permissible constructions of a pension scheme against the consequences they produce in practice. Technicality is to be avoided. Nothing to do with costs. If the consequences are impractical or over-restrictive or technical in practice, that is an indication that some other interpretation is the appropriate one. Thus, in the National Grid case, to which I refer below, where there was a choice of possible constructions, Lord Hoffman held that the correct choice depended upon the language of the scheme and the practical consequences of choosing one construction rather than the other. That National Grid judgment isn't in the bundle. The first instance judgment of Mr. Justice Robert Walker, as he then was, is in the bundle, but in the House of Lords, Lord Hoffman was giving his views as reported here by Lady Justice Arden in a case where the focus was on, as you might appreciate from what she's just said above it, the over-restrictive or technical nature of one of the constructions that was competing for the court's attention. Nothing to do with cost control. And that's all that is said about the dictum of Mr. Justice Millett in the judgment of Lady Justice Arden in British Airways. What she goes on to consider in this judgment is not that part of her judgment, paragraph 28 from British Airways. It's the third point, that is paragraph 29 from BA, same page, same column just below. Each new provision should be considered against the circumstances prevailing at the date when it was adopted. It is that part of her judgment in BA that she goes on to discuss in more detail in paragraph 31 and onwards of her judgment, and doesn't return to the Courage dictum or say anything more about it. And so we have support from an eminent authority at appellate level in this case for
I'm sorry to interrupt you, Mr. Spink. Does she not come back to the question, not explicitly by reference to courage, paragraphs 46 to 48 of her judgment?
I'm sorry.
Because she looks at what Mr. Justice Warren said about the starting point in relation to powers to amend, and she seems to me to disagree with what he says. See paragraph 48.
Yes, she does say more about it. Yes, the idea that, as the judge said, the power of amendment should be interpreted with greater liberality is not one that she favours. That's, I think, been addressed in has been addressed in the skeletons under the question of whether powers of amendment should be, generally speaking, construed more liberally, not specifically in the context of commercial consequences. But I entirely take your lordship's point. That is relevant to the submission, and it would tend to support the position that one needs to be very careful about taking a more relaxed attitude to construction in relation to a power of amendment than elsewhere. But the other thing that she reiterated in this judgment, which is picked up in Bernardo's, is the no predisposition to the correct philosophical approach point. So that, if you go back to the citation from British Airways that starts in the very long paragraph 30 of this judgment, it's her fifth point, paragraph 31. At the end of the day, however, the function of the court is to construe the document without any predisposition as to the correct philosophical approach. I think that Lady Justice Arden is the originator of that principle of construction in the context of a pension scheme, which has been much adopted since, and which came originally from the BA judgment. That feeds into my paragraph 28 point, that Bernardo's paragraph 28 point, which is, it's all very well saying that you can take into account the commercial costs of continuing with future accrual when construing a power of amendment, which if you went one way would enable you to terminate that accrual, and if you went the other way you wouldn't. we wouldn't say that that could never be a factor, but you've got to be very careful about not effectively ending up construing it with a predisposition in favour of the employer. Commercial exigencies could be not employer-centric or member-centric. They could be shared commercial exigencies. It could be very well accepted that, given current commercial circumstances, on all sides an amendment is required. But that's not the kind of commercial exigency on which the BBC relies. They see this power of amendment as a tool in their armoury for cost control. That's different, and we seek to resist that approach. The judge dealt with it in the way that he did in his judgment, and as a matter of law, any approach that transgresses with the fifth principle in BA, at para 31 from BA, and para 28 at Bernardo's in the Supreme Court, it cannot be right. And that's as a matter of law. So can I just conclude my submissions on reasonable and practical effect by turning a bit more specifically to the practical concerns that are said to arise on the judge's interpretation of the third proviso. It's relevant that in 1949 the BBC pension was very different from what it is now, because it was, as I've explained at some length, primarily a long service reward. Not only does it make sense in that context for the drafter to protect the member's interest in making it through to normal retirement age in the service of the BBC and receiving the pension as set out in the 1949 deed prior to any amendment, but it also means that there was a natural cost control on the scheme. Only those making it through to NRE in the service of the BBC would even receive a pension at all. It would naturally have been envisaged that many would leave and just receive a return of contributions with interest, and others would be dismissed, which would have had the same effect, and contrary to what's said by the BBC in paragraph 16 of its supplemental skeleton, would not have required any separate contractual agreement with members in relation to benefit change. So that's the first natural cost control, or the first cost control inbuilt effectively into the scheme at its outset. The other at its outset is that the third proviso itself enables substantially prejudicial benefit changes to be made, subject to two caveats with which we're all very familiar. We say that shouldn't be dismissed as impracticable or undesirable in a cost control situation. No doubt the drafter would not have included it if he thought that it could never practically be used. And there would have been, and is no reason to assume, that active members would never accept a substantially prejudicial amendment to benefits, at least if this meant them receiving some incentive outside the scheme. That's not the same as receiving substantially equivalent benefits within the scheme, which is exception B, but it's something that would make them or encourage them to vote under exception C. And that might be extra pay or an alternative benefits in another scheme. And also, calling a meeting and getting a majority vote of those attended should and would reasonably have been regarded as a practically easier route than doing it through a multitude of individual member negotiations and agreements. So that's, if you like, the second cost control built in 1949. And the third is that, as regards employees who've not yet started to work for the BBC, an employer is always able to offer different terms to new employees, and then could amend the scheme to reflect that fact to the extent that those benefits were to be provided to those new employees in the scheme, because then it's not a substantially prejudicial amendment to the interests of existing active members, because the new members didn't have any existing interests. but nonetheless, in order to record in the scheme governing provisions, what the benefits payable to this new cohort who've just come in would be, you might very well make amendments to the scheme to make sure the scheme documentation properly recorded what was going in. Those amendments could be made under the power of amendment, as I say, without offending the FETA for the reasons I've just given. So there were natural controls and other mechanisms under the Trust Deeding Rules in 1949, and that's all before we get to the more dramatic option of terminating the scheme. But as we have already noted, in 1949, in terms of commercial outcome for the BBC, that would not have been anything like winding up the scheme in 2024, because none of the statutory protection for members' accrued rights that now exist and have existed since in part the 80s, but mostly in the 90s and since, were in place. In which case, termination under Rule 22 was a cessation of contributions, and that was the end of it, whatever the funding level of the scheme from the BBC's perspective. Moving on, finally, to the current deed, we have the same point essentially in relation to the third proviso. We say, even in current scenario, modern day terms, it's perfectly rational, certainly not incoherent, for the drafter to have envisaged that amendment to the scheme's benefit structure could be effected by negotiation with the membership, especially in circumstances where the BBC always had the option of ceasing to make contributions or dismissing employees as their final backstop. And whilst, of course, it would partake in those negotiations in good faith, it would naturally have a strong position in any such negotiation. The drafter in 1949 could be taken to have understood that fact, and the same goes in the modern day era. Further, and this is the point that we made in the last two sentences of paragraph 68 of our skeleton, if interest means what the judge found it to mean, the next question will be what factors are relevant when the actuary is determining whether a particular amendment does not substantially prejudice the interests of active members. That's the reserved matters that I took you to. And the answer to those questions will inform the nature of the changes that the BBC is actually able to make to the benefit structure of the scheme, while still satisfying the A exception that there is no substantial prejudice. We don't yet know how those questions of substantial prejudice will be answered, but it simply highlights the point that the A exception exists, and the drafter can be taken to have understood that it provides some genuine scope for the BBC to amend the scheme, even where a member's interests are affected by the proposed amendment. And putting this into play in the commercial exigencies argument, the cost of the scheme, it's very difficult to calibrate the weight that the BBC's commercial exigencies argument should have when how it will actually play out in practice is unclear. And it just goes to show that the commercial exigencies point is quite a complicated one in a modern day scheme such as the BBC's, with a large membership and different groups and classes of member. And the very simple bold point that cutting future accrual must cut the cost to the BBC for cutting future accrual either for all active members or certain groups, must materially cut the costs in a way that the original drafter of the power of amendment would have considered was an appropriate amendment to be made without going through the hoops of the proviso is a big statement, and one that shouldn't be simply applied on the assumption that that is the only way in which the commercial exigency argument should run or conclude. Whatever the position is, what we've said about so far about the third proviso is that it's plainly wrong for the BBC to say in paragraph 19 of its replacement skeleton that on the judge's interpretation of the third proviso, cost issues cannot be addressed by the BBC. They certainly can. What the outcome will be is not necessarily clear, but there is a route through the third proviso. It's simply even more extreme to say, as they do in paragraph 16 of their supplemental skeleton, that on the judge's interpretation of the third proviso, the BBC was forbidden in 1949 from making an amendment that reduces future accrual. Clearly that's not correct. And that's an overstatement of the case significantly. Finally, under the current Deedham rules, there are also other levers through which it is envisaged, or would have been envisaged by the drafter, that cost can be controlled. In one particular that I will take you to now, in respect of the extent to which pay rises are pensionable, through determining the extent to which any pay rise is pensionable. Let me start that again. One example is the BBC's ability to control cost under the 2000 definition of basic salary that is discussed in BBC and Bradbury. That is a cost control mechanism. It doesn't stop members accruing into the future, but the ability to determine in its own discretion that future pay increases that members receive will not be pensionable is a significant cost control. In addition, let me show you, please, Rule 2.6, compulsory cessation of membership. That is supplemental bundle tab 10, page 128. A member will cease to be an active member if his or her contract of employment changes to be one of a non-pensionable nature, as determined in either case by the BBC. That reinforces the fact that if the BBC can negotiate with a member a non-pensionable contract of employment, they will then, within the scheme, cease to be an active member. Now, clearly, the BBC couldn't unilaterally amend an active member's contract to state that their employment is no longer pensionable. But the rule as drafted does envisage that any change to the employee's contract will be as determined by the BBC. And as part of the current Deedham rules, it's relevant to the interpretation of the power of amendment as enshrining a particular cost control mechanism. All of these points militate in favour, we say, of the conclusion that the judge's interpretation of the third proviso was neither impractical nor over-restrictive, and also that it does not conflict with the commercial exigency element of the Courage dictum, whatever precisely the scope of that is intended to be. Certainly not sufficiently to outweigh the textual and contextual indications as to the meaning of interest in the third proviso that the judge relied upon. one other reasonable and practical consideration, which is stepping away from cost. We say there's a practical consideration that militates in favour of our interpretation. On our interpretation and the judge's interpretation of interests, in respect of any given amendment, the trustee would ask the actuary to determine whether to certify that the member's interests are affected. On our and the judge's interpretation, that's a relatively straightforward question, as the judge said at paragraph 42. The focus of the inquiry is on the position of the active members, the position that active members have under the terms of the deeding rules as they presently stand prior to the proposed amendment, compared to their intended position if the proposed amendment or modification comes into effect. On the other hand, my lady, my lords, the BBC's case is that the drafter chose to use the word interests in a very much narrower sense, not even in the sense of accrued rights, but rights to benefits to which a legal entitlement or claim has already arisen by reason of the active member's past service. And it follows that absent a court argument of the sort that we're having, the actuary has to understand that interest means what the BBC says it means, rather than in understanding it in a much more, we would say, natural and ordinary meaning. That is an impracticable construction, or a much more impracticable construction than ours, in terms of the burden that it puts on the actuary. That's all I'm going to say on reasonable and practical effect. I have concluded that the submissions I made this morning on 1949 and Rule 22, other than coming back to Rule 22 to talk about the significance of the right to terminate, cover all of my points. They were in sufficient detail for my current purposes, allied to those that I made in my skeleton, which means that I come now penultimately, and as I said shortly, to the final salary link. Our primary case and I should say that the essence of our case is at skeleton 71 to 75. So please read what I say now in light of that, what is in the skeleton. Our primary case on the question of the meaning of interest is that it's broad enough to include an interest in future accrual, as you know. If we're right about that, then it follows without dispute that the interests of the member also include an interest in the preservation of the salary link. And it's an interest in what the quantum of your accrued past service rights will be as a result of increases, if any, in the future to your pensionable salary. That's what it is. We don't understand that the BBC is saying that the representative beneficiary could win on the question of whether interest includes an interest in future accrual but lose on the final salary link. So we're approaching it on the basis that we've lost on whether or not interest includes future accrual. That thought experiment, if I can put it that way, that hypothesis puts us firmly into the track or the position occupied by the cases starting with Courage and following on, the Courage line of authority. The difficulty for the BBC is that it's trying to find a route through which it can say that the interest of a member doesn't include a final salary link, whilst at the same time saying that they do not need to challenge the Courage line of authority. It's very important to understand that that's been made very clear to us as representative beneficiary in defining the scope of the arguments that we should be advancing both at the trial and in particular on the appeal. It is right to observe, as learned friend Mr. Green does in his skeleton, that nowhere in the BBC's skeleton is there any reasoning set out as to why courage might be wrong. It is suggested that for the first time in any case since courage, and there have been a number, where the question of the final salary link has been considered against the background of a fetter or a proviso that protected accrued or secured rights, benefits. For the very first time, some doubt has been cast in the recent decision of Mr. Justice Michael Green in the Chancery Division in Newell. I'm not going to say anything more about Newell in my submissions because the reasons why that doesn't advance debate against courage really at all are succinctly set out in my learned friend Mr. Green's skeleton, and I'm certainly not going to repeat what he said there. Other than that, in every case in which, if I may say so, experienced pensions leading counsel have appeared, there are a lot of them, it's been made clear by all of them that they do not regard it as open to challenge at first instance, and it would have to be a point that would be argued in first principles on appeal. I took the same stance as that. I took precisely that stance in Wedgwood. You can see it, if you wish, in the judgment. We conceded, for the purposes of the first instance hearing, that fetter protecting rights must be treated as including a final salary link, although we reserved our position to argue to the contrary on appeal, which never happened because we won substantively. The idea of reserving one's position may or may not have started with me. It probably didn't, but it was something that you can see from the reports and other cases was done in a number of those cases. And all of the judges at first instance who've considered courage in this context have quite rightly accepted that, and furthermore have not, even obiter, suggested why it might be, if it is the case, that courage could be wrong. They've just noted the point, rightly. The BBC made it clear that it was not going to, and it would not, challenge head-on courage. Its approach is to try and distinguish this proviso from the courage fetter and the fetter in the cases that have applied courage since. Courage, to remind you, was benefits secured by past contributions or contributions already been made. That was extended to accrued rights by Mr. Justice Newey in Leeds, and the same trend has been followed in other authorities, and I'm going to show you one only of them in a moment, and that's G4S, Mr. Justice Nugent, who pulls it all together very neatly into 5 paragraphs, which is worth noting. But we're not here to debate the reasoning behind, or the correctness of the reasoning behind the dictum encouraged from which all of this started, which, just to remind you, well, I don't need to remind you because you're going to see it when I show you G4S in a moment. So no argument has been advanced as to why courage was wrongly decided. And ironically, the point of distinction that my learned friend seeks to draw with courage line of cases is that in this case, interest actually means, according to him, less. The scope of it is narrower than accrued rights or benefits secured by past contributions. He has to say that because otherwise he would be conceding without, if he's not going to challenge coverage, that there's a final salary link. But it does seem very counterintuitive to take that approach to distinguishing coverage in a case where the feta is, the word is interests, with all the breadth potentially to it that carries with it, as the judge indeed himself found here. So much so that the judge concluded that it went as far as including future service benefits as well, rightly, for all the reasons I've said. Anyway, be that as it may, that is the position of the BBC on the final salary link issue. Can I take you, please, to G4S, which is at bundle 3 in the authority bundle, tab 28, and ask you to go to paragraph 32. I mean, there's a lot of wisdom in this judgment on a number of points, but I won't detain the court's time on anything more than is central. Mr. Justice Newey, just so you are aware of the structure, starts with an introduction at paragraph 1. His facts are at paragraph 7, and his discussion starts at paragraph 20. And under the heading of linguistic arguments that starts at paragraph 23, we get to what is in the relevant passage. And essentially, the entirety of 32 to 37 bears reading. 32 is helpful because it tells you what the essence of a final salary scheme is, authoritatively, albeit at first instance. I'm not going to read it out, but I highlight the first two sentences in particular, but all of that paragraph is helpful and relevant in understanding, as I'm sure you already do, how these schemes work. The key passage in that paragraph is in the final three sentences. In that way, the pension attributable to each year of his pensionable service cannot be known, cannot be quantified until the final salary is identified. But the identification of his final salary does not change or add to the benefits already earned. It identifies what they are. The analysis of how a final salary, I'm reading on to 33, works has been consistently adopted in the authorities. One can start with in re courage. You can see the approach that Mr. Justice Millett took in that dictum set out there. In the absence of express definition, I see no reason to exclude any benefit to which a member is prospectively entitled if he continues in the same employment and which has been acquired by past contributions, and no reason to assume that he has retired from such employment on the date of the employer's succession, when he has not. I'm not here concerned with whether Mr. Justice Millett was right in his decision on the effect of the proviso to the amendment power. That turns on whether he was right to say that there was no reason to assume a member had left service when he had not, or whether the rights that a member is to be regarded as having secured to him or as having accrued at any point in time should be confined to the rights he would have if he left service at that time. No argument was addressed to me, as you can see, both counsel recognising that it's settled at High Court level. And he goes on to say, I'm certainly not going to express a view one way or the other in the absence of any argument, which, ironically, at court of appeal level is the situation in which we find ourselves now. What this passage from his judgment, to my mind, undoubtedly does illustrate is that if the member does remain a member in pensionable service beyond the date of amendment, which, my lady, my lords, will be the case well, no, I'm sorry, I'm not going to make that point. If the member does remain a member in pensionable service beyond the date of amendment, it can be seen that the prospective entitlement to a pension based on his future final salary was something he already had at the date of amendment. Then he goes to Briggs and Gleed, which is Mr. Justice New, which I mentioned earlier. I can see no compelling reason for taking accrued to have a narrower meaning than secured in the present context. Then Mr. Justice Arnold.
That's a misprint, is it?
I'm so sorry?
That's a misprint in the quote from Mr. Justice New. I can see no compelling reason for taking accrued.
I cannot see a compelling reason for taking accrued to have a narrower meaning than secured. It was being argued in that case that accrued was narrower than secured, and therefore courage could be distinguished.
Oh, I see.
Do you see?
Okay, thank you. Yeah.
And he's saying no, they're the same for present purposes. I accept, my lord, that there's a slight shortcut involved, not taking you to the report of each of these cases, but I hope it's sufficient to do it in this way, because they're all, the critical parts are gathered together here. All of these cases are in the bundle, by the way, if necessary. Then we have HR Trustees against German, which is also known as the IMG case. And you can see what Mr. Justice Arnold said in 2 paragraphs of the judgment. And then finally, to complete the array of first instance judges with a greater or lesser experience of pensions, in this case, great experience, Mrs. Justice Aspin as she was, we have the dictum from a different MNRPF case from the one that I showed you a few minutes ago that appears at paragraph 36. And he concludes at paragraph 37, it can be seen that the analysis adopted in these authorities entirely supports Mr. Hitchcock's submission that in a final salary scheme of the N60th type, what a member earns or accrues by each year's pensionable service is not 1/60th of his then salary, but 1/60th of his final salary. That if he remains in service after the scheme has been closed to future accrual, he enjoys a continued link to final salary. The extra pension he receives if his salary is increased is not earned by or attributable to his post-closure date service, but is inherent in the rights he earned by his pre-closure date accrual, or in other words, that his post-closure date service does not qualify him for further pension rights. It simply quantifies the right he already has. In short, in summary, in a conventional final salary scheme, an amendment power that protects benefits that are accrued or secured as a result of past service or past contributions protects the final salary link. And that is the law, unless and until arguments are addressed as to why courage is wrong, which is not the position on this appeal. The point of distinction doesn't work in our submission. And the idea that the interests of an active member comprise a narrower concept than the concept of benefits that have accrued or been secured is an inherently implausible result. And just highlights again what I have already said under the heading of future service accrual, the difficulties in the BBC's narrow definition, if I can put it that way, of interests. The idea that the fault line should be drawn at the point where they ask it to be drawn is even more difficult in the context of the word interest, where they seek such a technical and narrow meaning for interest than it might be in a case where the position was that they accepted that it protects fully accrued rights. So, that's what we say on final pensionable salary, on the final salary link. On Bradbury, I repeat what I said in, I think, 2 short sentences in my opening. It's clear from the report that the scope of the power amendment was not an issue and was not considered by the Court of Appeal in that case. I also went on to say that, in addition, the Court of Appeal's decision in that case is perfectly explicable on other grounds. Those are considered at some length in my learned friend Mr. Green's skeleton. I'm not going to preempt those. Safe to say that we support those arguments to the extent that it's necessary to consider them in order to provide an other grounds explanation of the decision from the one that the judge himself provided in this case, which we support and ask you to uphold. Those are my submissions, unless I can assist you any further.
Thank you.
Yes.
Mr. Green.
Thank you very much. A little bit of furniture
removals.
Right, thank you.
My lords, my lady, as you will have understood from our skeletons, the trustee's principal concern in this appeal has been the use that the BBC was attempting to make of the Bradbury decision, what was decided in that case in the absence of the trustee. But before addressing you briefly on Bradbury, and I will be brief, in light of my Lord Justice Lewison's comments to my learned friend Mr. Tennant, with which we respectfully wholly agree, we really will only do so shortly. There are 2 matters arising out of the BBC's and the representative beneficiaries' submissions on which the trustee would like, with your permission, to comment. The first matter concerns alternative B in the 3rd proviso to the amendment power, the substantially equivalent benefits provision, which, as you know, as you're very familiar with, is at Supplemental Bundle tab 10, 217. Well, we appreciate that this court is already very much focused in relation to this provision, but we just wanted to draw together some points in relation to it. The first point we would like to make was, as noted by my learned friend Mr. Spink this morning, actually introduced by the trustee in footnote 13 of its original skeleton. You'll recall it from this morning. It's at Core Bundle, tab 3, page 52, and it was the point which picked up on the apparent equivalence of interests and benefits as being used in the in alternative B to the 3rd proviso. Looking at alternative B to the 3rd proviso makes the point without need to see how we articulated it in our skeleton. As I say, it's a supplemental bundle 217. But as you will recall, we've looked at this many times, one of the letouts is if the actuary certifies that to the extent to which the interests of members are so prejudiced, substantially equivalent benefits are provided or paid for by the BBC or the trustees or provided by legislation. So there's an appearance of equivalence of the concepts of interests and benefits, at least for the purposes of the operation of that particular provision. And that was a point, if I may say so, that my Lady Justice Falk had independently early alighted with my learned friend Mr. Tennant during his submissions yesterday as potentially providing an insight into what the word interests as contained in the third proviso might be getting at. Namely, that the third proviso just might be said to be concerned with matters on the benefits side of the line and not extending, as was being canvassed in Mr. Tennant's submission, to pretty well any other scheme-related matter, including administrative matters, no matter how remote as you might conceive of and catalogue. Now this point about interests and benefits is, I think, an interesting one, because it invites a question as to what the word benefits, if this provision is concerned with matters on the benefits side of the line, well, what follows from that? And as regards what a reference to benefits, where there is no temporal limitation in the provision, using that word, as regards what a reference to benefits, where there is no temporal limitation, might actually convey, there is a paucity of authority. As you know, one of Mr. Spink's points in this case is that interests is not subject to temporal limitation. It's not past interests, it's not past accrued interests, it's not interests already accrued, it's just interests. But similarly, in relation to the point that I've just made, we're dealing with the possibility that benefits are in some sense coterminous with interests, and they similarly are not temporally limited. So what might the reference to benefits signify in a pensions context, in a proviso, in the absence of temporal limitation? And it's interesting, and I put it no more highly than this in my neutral capacity on behalf of the trustee, to note the following in Mr. Justice Millett's judgment in Courage. If I could just, this is a point which just pretty well only just occurred to me, I have to say. If you wouldn't mind to go into Courage in Authorities Bundle tab 2, at pages 48 to 49, you see the passage which you've looked at on several occasions, which is the final salary linkage passage. And as you'll recall, what Mr. Justice Millett was concerned to do in that passage was to put a construction on the expression, as appears just below letter H on 48, must not vary or affect any benefits already secured by past contributions in respect of any member without his consent in writing. If I might ask you, in pencil, to put square brackets around the words already secured by past contributions, or metaphorically, or in your own mind, put square brackets around already secured by past contributions, and then move across to page 49, second line. There was some dispute whether benefits, open square brackets, already secured by past contributions, close square brackets, means benefits based on salary at the relevant date. Sorry, I should pick that up. Or includes, and this is the important point, there was some dispute whether benefits includes the prospective entitlement to pensions based on final salary. Reasoning. In the absence of express definition, I see no reason to exclude any benefit to which a member is prospectively entitled if he continues in the same employment, open square brackets, and which has been acquired by past contributions, close square brackets, and no reason to assume that he has retired from such employment on the date of the employer's cessation when he has not. The contrary argument places a meaning on secured and accrued which is not justified. Now, the point I'm making, which I think will I hope, be immediately apparent that although obviously I accept, and as is apparent from the final sentence that I just read, the focus of what Mr. Justice Millett is addressing is the secured or accrued consequence arising out of the past service focused nature of the protection in this particular case. But it is at least interesting to note that in construing provisos to, or a proviso to an amendment power, and in addressing the concept of benefits, which plainly underlies what he says, in the absence of express definition, I see no reason to exclude any benefit from the concept of benefits, to which a member is prospectively entitled if he continues in the same employment, and no reason to assume, when construing such provisos, that he has retired from such employment on the date of the employer's cessation or the relevant amendment, when he has not. Now, I make no positive submission in relation to that. If that's a matter, as it were, for other parties and perhaps on other days. But what I do say, or we say to you is this: you don't need, in this case, positively to equate interests with benefits, and you don't need to decide anything in relation to interests actually on the basis that they are limited to benefits, because, and we'll come on to this in a moment, as my Lord Justice Lewison said, what you're actually concerned with in this case is to answer the questions which are actually before you. And the questions that are actually before you concern the application of the word interests to the particular circumstances raised in the Part 8 claim. And I'll come on to those in a second.
But just staying for a moment with this word benefits.
Yes.
In exception B, the proviso,
Yes.
what is being contemplated is that the actuary certifies that the interests of the members, whatever interests mean, have been substantially prejudiced, but they are going to get equivalent benefits one way or another. But those benefits must, ex hypothesi, be future benefits which the members have not had before, but which are now to be given to them in recompense for the substantial
For what has been taken away.
Substantial prejudice to their interests, whatever they are. So how does the word benefits help you on, or help one, I should say, on deciding what is meant by interests?
No, I merely draw the attention to the fact that interests and benefits are being used coterminously here. And at the end of the day, you have to decide what interest means. Naturally, that's what's before you. I just draw attention to the fact that in the context of benefits, Mr. Justice Millett actually gave an open-ended reading to benefits, which was only pared down by the fact that in that case, the proviso was backward-facing. That's the only point I make for your benefit. So far as regards the point you just made to me, my Lord, what is contemplated under Alternative B is that there is an amendment which, if it were to be made, would substantially prejudice interests. And in order for that amendment to go through, whether the interests are past interests, which would be my learned friend Mr. Tennant's case, or past or future interests, which would be my learned friend Mr. Spink's case, substantially equivalent benefits have to be provided. And so in a sense, it's neutral as between the two of them, because it could embrace either of their cases. But if you'll permit, I was just going to go on to that in a bit more detail, if that's all right. Thank you. Now, when we made the point at footnote 13, the point that there was this apparent equivalence of concept, at least being played out in Alternative B, we did not go on to say, although it was and is the view of the trustees, that actuarially certified substantially equivalent benefits can just as easily embrace future service benefits as be confined to past service benefits. And as I say, we're not taking sides in making this point, but we do feel the point has to be made. Actuarially certified substantially equivalent benefits can just as easily embrace future service benefits as be confined to past service benefits. It's a point with this segues off the question, I think, that my Lord Lord Justice Lewison has just asked me. And two simplified examples may be used to illustrate this. The examples are deliberately abstract and not BBC fact specific. I just want to keep it simple. First, a defined benefit example. For future service, it may be desired going forward to change the ingredients of pensionable salary so as to exclude certain items. In that case, the scheme actuary could certify for substantially equivalent benefits on the basis of a more generous accrual rate, say N50ths instead of N60ths. The less generous value of pensionable salary going forward then being counterbalanced by the more generous accrual rate going forward. It's perfectly possible for the actuary to carry out just such a calculation in relation to future accrual. Second example, a defined benefit to defined contribution, conversion example. Suppose that under the defined benefit status quo, future service may qualify for an N60th times final pensionable salary benefit based on a given final pensionable salary calculation and a given rate of member contributions. So suppose under the existing defined benefit status quo, future service may qualify for an N60th times FPS benefit based on a given FPS definition and a given rate of member contributions. If it is desired for the future to convert to DC accrual, the scheme actuary may calculate substantially equivalent benefits by working out what combined member and employer contributions going into a pension pot having projected investment returns as calculated by him applied to that pot would be expected to produce an equivalent outcome. Now, many other future-looking examples could be constructed. And the underlying truth of the matter is that placing values on future matters, as well as past matters, is part of the everyday practice of actuaries, whose job it is to calculate future contributions required for scheme funding purposes. And in that context, and we went through this before the court in Atos, my learned friend and I, future salary increases may be brought into account, future membership attrition or increases may be brought into account, estimations as to that, future investment returns are brought into account. It's meat and drink to an actuary to be looking into the future and to be projecting and making calculations, be they funding calculations or, in this context, substantially equivalent benefit calculations in order to carry out his or her function. And so there is nothing preventing the scheme actuary, as a matter of calculation, certifying for substantially equivalent future service benefits under Alternative B of the third proviso, any more than there is anything preventing the scheme actuary, as a matter of calculation, certifying for no substantial prejudice to future service benefits under Alternative A to the third proviso. Though, whether it's looking to the future or looking to the past, frankly, the actuary can do the job If it's a job involving calculation, he can do it by bringing back to bear calculation methodology. But further, as my learned friend Mr. Spink drew your attention to just half an hour ago by reference to the Atos case, as this court held in Atos, there's absolutely no difficulty with entrusting to actuaries qualitative decisions falling within their professional expertise, where they bring to bear professional judgments in order to make judgments as to substantial prejudice, in order to make judgments as to substantially equivalent benefits. Of course, that wasn't the issue in Atos itself, but what Atos recognised, what this court recognised, was that judgments of a qualitative nature fall within the province of the expertise of actuaries. But the examples that I've just given you are examples where calculated conclusions can be reached, probably without any qualitative element. Now, this leads on to the second point in relation to this first matter. And this is a point which arises out of a comment by my Lord and Justice Lewison yesterday. This linked use of interests and benefits in alternative B to the third proviso is of note, not merely for the possibility, and I put it no more highly, of conceptual equation of interests and benefits, significant as that might or might not be, but for a further reason as regards the disposition of these proceedings. And that this second point arises out of an observation of my Lord Justice Lewison made yesterday to Mr. Tennant in response to Mr. Tennant's point that interests on the representative beneficiaries case was an impossibly wide concept. In response to that, my Lord observed that this court was only concerned to answer the questions before it, which, with the greatest of respect, was and is plainly right. And it's an observation which does invite a looking back at those questions as they had been raised in the Part 8 claim form, and as is a convenient place to take them up, as reproduced in the answers supplied in relation to them in the order, which is Core Bundle, tab 6, pages 85 to 86. Core Bundle, tab 6, pages 85 to 86. That's the order. And as you're familiar with this, you've got an A, B, C, and D, which are the specific questions. And it's salutary to note in relation to these questions that these are the BBC's questions. Right? This is the BBC's Part 8 claim transmuted into the judge's order. Obviously, the questions were formulated following discussion with the trustee and the representative beneficiary, but these are the questions which were put before the court for answer by the BBC. A, B, C, and D have received answers, and those are it's those questions which are live in relation before you. At least B, C, and D are in relation to the appeal. But it's instructive to look at E, because E was those members' interests in some other, and if so, what right or benefit. Now, it's instructive to look at E for two reasons. E invites construction of the word interests on the basis that the expression is concerned with rights or benefits. This claim was never structured on the basis of answering wider questions as to whether interests was a concept wide enough to embrace matters other than members' rights and benefits. So when the BBC takes aim at whether matters falling outside of rights and benefits might fall within the concept of interests. It's not actually a question which they were inviting an answer to from this court. And the second point in relation to E arises out of the judge's answer to the question. Neither the BBC nor any other party suggested before the judge that there was anything else beyond A to D that was to be decided in these particular proceedings. Hence, the judge's answer to E. The court does not provide a separate answer to this question. And the judge's explanation of that is at paragraph 88 of the judgment. It's at core bundle 8113. Paragraph 88. As I see it, this final question was included as a catch-all. I was not addressed directly on it. I consider the arguments canvassed before me have been sufficiently addressed in relation to A to D. I therefore then intend to provide any answers. So, that's just scoping out what is actually before you, and that there may be other arguments to be had as to the meaning of the word interests in other contexts for other circumstances, but it's squarely B to D which is the subject of this appeal, and squarely B to D which will be invited to make findings in relation to. That's what the claim is about, that's what the appeal is about. Now the second point on the BBC's submissions that we wanted to pick up on was its use of Rule 22 of the 1949 rules. And as you'll know, Rule 22 is at Supplemental Bundle tab 2, pages 31 to 32. I just refer to it. I wasn't proposing actually to go to it, but I've got it open by my side. So the second point relates to the use that the BBC was making of Rule 22 of the 1949 rules, and then Rule 18 of the current rules, which, as you know, are at Supplemental Bundle tab 10, 214 to 215. And the use that the BBC was making of those rules to contend that because the BBC and the trustee had a power to terminate the accrual of future service benefits outside of the amendment power, it made no sense to construe the third proviso as preventative of the making of amendments having that effect. And bearing in mind, as Justice Lewison rightly observed, if I may say so, about an hour ago, of course, what Rule 22 and Rule of 49 and Rule 18 of the current rules are actually about is a power in the BBC to terminate its obligation to make contractual contributions. It's actually, that's the way in. Actually, that's the gateway to those provisions. It's not as such a termination of accrual vote-facing provision, although that may or may not, under the current rules, be the consequence. And it certainly doesn't relieve the BBC under the current pensions regime of obligations to contribute which have been imposed by statute, which is, and the material's not before you in the court bundles, but as you may know, since 1997, Section 56 of the Pensions Act 1995 introduced the minimum funding requirement, which was a statutory basis for having to minimally fund pension schemes, irrespective of the strength of the employer's covenant. And these days, there is a far more extensive regime, which subsists under Part 3 of the Pensions Act 2004, under which, essentially, the employer is on the hook to fund ongoing pension schemes on an ongoing basis.
Is that the Section 75?
No, that's the liability, okay, that cuts in if the scheme winds up. Right. Yeah? So one way or another, the employers are now on the hook, putting it very broadly. Yeah? And they have been actually in one way or another since 1995, since the 1995 Act. Yeah? Section 56, minimum funding requirements, Section 75, fund the scheme for its deficit on a winding up. Each of those funding regimes has been tightened over the years. The ongoing funding obligation is now to be found in Part 3 of the Pensions Act 2004. It's called scheme-specific funding, and it basically means you've got to fund the scheme, obviously. Over time, what actuarial assumptions, etc., all these things are subject to negotiation. But you do have an ongoing obligation to fund the scheme. Section 75 continues to apply if the scheme goes into winding up. But all that these provisions are, as by way of gateway, is a power of, certainly since 1997, of somewhat limited value to the BBC, emphatically since the Pensions Act 2004, to terminate contractual contributions. Now, as I say, that's almost a sidebar, because I want to actually engage with the way in which the debate, if I may, has occurred in this court. As I say, the BBC's point, and we see the point, is that because the BBC and the trustee, when you get to Rule 18, it's Rule 18(2)(b), that's where the trustee comes in, had a power to terminate the accrual of future service benefits once contractual contributions have ceased. Outside of the amendment power, it made no sense to construe the third proviso as preventative of the making of amendments having that effect. And the court was, if we may say so, early on to this point as well. The point was picked up in particular by my Lady Justice Falk, who observed that Rule 22 was at the end of the day, the 1949 version, before statutory funding. The Rule 22 was at the end of the day really just a winding up provision. It was the gateway, maybe termination of contractual contributions, but it was actually a winding up provision. And as your ladyship put it, I think more than once, but you put it very clearly, yesterday, transcript day, page 113, pages 8 to 11. As you said, it's a winding up provision under which the termination of future accrual is connected with the scheme's cessation. And as we understood it, you were just querying at that point, and as I say, we're not taking sides in relation to this, but you were querying, as we understood it, therefore the weight to be attributed to the existence of the rule when construing the third proviso to the amendment power, enabling amendments which would generally, if not actually exclusively, be made in the context of an ongoing scheme. What weight should we be giving to that which occurs on the road to winding up in circumstances where what you're actually doing is asking us to construe the meaning of the word interests in the third proviso to an amendment power, which the working assumption in relation to which is not the scheme is in winding up, but that the scheme is ongoing, and that the interests that may fall to be protected on a winding up are surely not necessarily to be regarded as coextensive with the interests which might legitimately be expected to be protected in circumstances of an ongoing scheme and an amendment power under it. In short, there is absolutely no basis for construing the amendment power on the assumption that it's to be looked at through a prism of an imminent or inevitable winding up. It is an ongoing, organic thing dealing with an ongoing scheme and dealing with the interests under that scheme, however, whether according to the BBC or according to the Rep Ben, those interests are to be understood. And Malady's characterisation of Rule 22 as a winding up provision was actually acknowledged by my learned friend Mr. Tennant himself in his submission at day 1, page 120, lines 11 to 13. I don't know whether Mr. Senate intended to say this, but he certainly said it. It is a winding up provision. Now, the point that
I'm just
I'm
noticing the time.
I'm so
how,
sorry.
How long do you need to finish this
point.
point?
5 minutes. Perhaps I should go. Leave it till tomorrow.
Right. Okay. Well,
So sorry.
We're running well to time in any event. Hopefully we'll finish well within the morning tomorrow, judging by the timetable. But we'll see. Okay. Thank you. 10:30 tomorrow.